All right. Well, hello, everyone. Welcome to our topic today, which is Medicaid no spend down required for couples and for singles. Hi, my name is Lynn St. Louis, and I'm an estate planning and elder law attorney here at ELG Estate Planning. And I am happy that you're joining me today. You know, for a lot of our clients, their biggest concern is what happens to them, to their finances, if they should need long-term care, particularly expensive long-term care. So that's what we're going to be talking about today. As elder law attorneys, this really is our area of practice. It's especially Medicaid. Medicaid is a really confusing area, and that's what we are going to be talking about. I'm going to be sharing with you information and even some examples of how to avoid spending all of your money down on long-term care, or even having to spend down your money to qualify for Medicaid. So, and that's what our topic today is. If you have questions and you are on the Zoom, feel free to type them into the chat, and I definitely will answer those before we're done today. And if you are joining us on Facebook, go ahead and put your questions in, and they will be conveyed to me magically and put in the chat so I can answer those as well. So, all right. So, as I mentioned, the topic is Medicaid no spend down. Why am I talking about Medicaid? Well, the reason for that is that Medicaid is the primary payment source for long-term care in the United States. That's where most nursing homes are paid through Medicaid. Now, how do people typically pay for their long-term care? Usually people start paying through their own income and their own assets, and oftentimes people rely on family members to help out. Totally understandable. As long-term care typically is something that isn't static, that it continues and it progresses and it gets more and more and more. So I'm guessing that there probably are a few of you who are listening that have been a long-term care provider yourself for a family member, or have experienced long-term care in your family. I know I did in my family. Between my mom and dad, we experienced 14 years of long-term care. So that's quite a long haul in long-term care. So that's part of the reason I'm so passionate about helping clients and sharing information, this type of educational information with everybody, so that you have that to help you if you are dealing with long-term care event for yourself or for a loved one. So how do you pay for long-term care? Typically, people pay for it out of their own resources. What I'm hoping to convey to you today is that's not the only or necessarily the best way. Maybe when you're starting, but at some point in time, if you're facing skilled nursing at $12,000 a month, or even as adult family home or assisted living, that can be 5, 6, 7, 8,000, especially if it's memory care. People run through their resources pretty quickly if that's the case. If you have long-term care insurance, fantastic. That will help pay for long-term care. I have to tell you, most people don't. There's also a benefit through the VA. One of them is called aid and attendance, and that provides a stipend, which can help with long-term care. Or if you're a veteran and you have a service-connected disability, and it's a certain amount, then or percentage rather, then your long-term care may be paid for by the VA. That's not what we're talking about today. I just want to make sure you're aware that there is a VA benefit. And of course, if you have long-term care insurance, that's a benefit as well. How about Medicare? Will Medicare pay for your long-term care? No, it won't. There is a misconception or a misunderstanding about Medicare. Medicare is an insurance-based program. You turn 65, you get Medicare, it'll pay for hospital, doctor's visits, etc. Of course, you'll have your supplemental to pay for things that aren't covered by Medicare. Now, sometimes people think that Medicare pays for their long-term care expenses because of this. If somebody goes into a hospital and they're admitted and they're for 3 midnights, and then after they leave the hospital, they can't go home, they have to go to a rehab facility, then Medicare will pay for up to 100 days in a rehab facility. So let's say somebody has a stroke, they're in the hospital, they can't go home because they need rehab, they need occupational, physical therapy, speech therapy, they'll go to a rehab facility. Medicare will pay up to 100 days. For the first 20 days, they may pay the entire amount. After 20 days, it's a copay situation. But that's not long-term care, that's rehab. And let's say the person got the full 100 days at the rehab facility and then they can't go home. They have to stay at a skilled nursing facility because they can't go home. That's going to be private pay. Medicare stops. How are you going to pay? It's either going to be through your own resources, your long-term care insurance if you have it, or likely through Medicaid. So don't get confused to think that Medicare is what you can rely on for your long-term care, because that is not true. That's a misconception. So now that we've cleared that up, let's talk about Medicaid. For the most part, people have the idea that Medicaid is an impoverishment program, that they can't have any money. And frankly, that is not true. If you are married, Medicaid allows you to keep more money than if you're single. And if you are single, then yes, Medicaid requires, for the most part, a single person to have only $2,000 in what's called countable assets. So countable assets, we'll get into what those are. But Medicaid is not an impoverishment program for couples. Now, there is a misconception that people who are Medicaid millionaires get long-term care, and frankly, we simply don't see that. Our clients are not Medicaid millionaires, so that's not what we're talking about. So as we go through it, we'll talk about what can a couple keep without having to spend down. I'll give you some examples, no, we're not talking about people who are wealthy. For millionaires, Medicaid is not going to be an appropriate program for you. So how to qualify for Medicaid? Well, the first question, there's basically 3 things we look at: medical eligibility, income eligibility, and resource eligibility. So when it comes to medical eligibility, that's a pretty easy one to meet. I'm going to see if I can share my screen with you. And if I can, I'm not going to do it, but let me see if I can do that. Hold on just a sec. I'm hoping you can see this screen. Raise your hand. I can see some of you. Can you raise your hand? Does it say medical eligibility and show pictures? Great. Thank you. All right. So medical eligibility, if you are in a skilled nursing facility, obviously you meet these requirements of needing help with eating, bathing, dressing, transferring, toileting, movement. Even people that don't need this help, but maybe they have a cognitive disability, maybe they have Alzheimer's, for example, a very significant one, a disability, they're going to meet this criteria, even if they're physically fairly robust. And you may know somebody like that. They've got Alzheimer's, they can do all these things, but they need that kind of direction so that they are safe. That meets the medical eligibility criteria. So that's usually pretty easy to meet. Now let's talk about financial eligibility. So for financial eligibility, what we're talking about is income tests. So for income tests in a skilled nursing, that's pretty easy too. You know, if the skilled nursing facility costs $12,000 and your income is less than that, you meet that criteria. For at-home care or assisted living or adult family home care, you'd be surprised to know that in Washington State, 8,927 is the standard. So if your income is less than that, you meet the income eligibility criteria. Then there's another program we have in Washington. The reason I'm pointing it out is it's called Community First Choice, CFC, and the income standard for that is lower, but it has a special quirk to it that it doesn't have a look back to it. So that's an important program we're going to be talking about and how it impacts no spend down. So next, what we're going to be talking about is resource eligibility for the person who needs Medicaid. Yeah, they only can have 2,000 in countable. We'll talk about what's countable, what's not. The community spouse, and this is why I'm saying that Medicaid is not an impoverishment program per se for married couples, because you can see that the minimum amount, somebody who is what we call the well spouse, the person not needing care, the minimum amount they're allowed to keep in countable assets is almost $60,000, $59,890, up to $137,400 if the ill spouse is in Medicaid in a skilled nursing facility. To get that higher standard, the ill spouse has to be in the skilled nursing facility, and when they enter the institution, that hospital or facility, they had to have double that amount. So if somebody had double $137,400, they can keep half of that, or $137,400. So let's say they had countable resources of $400 when they went into the facility. Can they keep $200,000? No, but they can keep the $137,400. Let's say they had $200,000 when they went into the facility. Well, half of that is only $100,000, so that's all that they get to keep. The point of it is, though, is that how is anybody supposed to know these rules? You know, most lawyers don't know these rules unless what they focus on is Medicaid. So I want you to be aware, just keep in mind, not these numbers, but keep in mind the fact that if you are married in particular, there is money that can be kept, and exactly how much, certainly the lawyer can help you with that, but I want you to be aware that you don't have to spend down all of your money. And in addition to that, I want you to be aware of what we call exempt resources. What exempt resources are those resources that Medicaid doesn't count for a single or a couple. So let's say you have a house and you live in the house, and that house might be worth, if you're a couple, it could be worth $1 million. It does not disqualify you from Medicaid. And if you're a single person, the standard was just raised how much equity they can have. It's over $900,000. That house does not disqualify anyone from Medicaid. So is Medicaid an impoverishment program? You're a single person, you can have your house worth more than $900,000. You can have a car, all the personal property that you have, life insurance policy, which is very odd. The face value has to be less than $1,500. Really kind of a ridiculous rule. Who has a life insurance policy with a face value of less than $1,500? An irrevocable burial plan, cremation plan doesn't count. Burial plot or urn doesn't count. Business property that you rely upon for your income doesn't count as a resource. A long-term care insurance partnership policy doesn't count. Of course, if you have that, you're probably not looking for Medicaid, but if you do have it, you still should talk to an elder law attorney about planning, because sometimes policies run out. Sometimes they're only for 2 years or 3 years. And then what are you going to do after that? It's a great planning opportunity if you have long-term care insurance. And probably the most important planning tool that we have is a single premium immediate annuity. And that is used primarily for couples. We'll talk about that and show in examples how we use that. So I'm going to stop sharing for a moment. So I hear you. Somebody said it sounds like an impoverishment program to me, but we haven't gone through some of the examples to show you how the ability to keep resources. So, all right. Now, when you're thinking about Medicaid, one of the first things you're facing is you probably have yourself or a loved one needs long-term care. So you might be thinking about, how am I going to pay for it? I should be thinking about Medicaid. One of the things I want to point out to you is that unless this care is going to be provided in a skilled nursing facility, a nursing home, if it's going to be provided elsewhere, like at an assisted living facility or an adult family home, there typically are private pay periods. And those typically run 2 years, if not longer, for 3 years. So don't wait until there's no money left. Start planning when the person is facing care. There's a diagnosis of Parkinson's, of Alzheimer's, of, the multitude of diagnoses people face as they age. If that happens, of course, you have to kind of take time to grapple with this very bad news of a diagnosis, but see an elder law attorney to start getting your planning in place. Planning in place, first of all, means getting the right estate plan in place. We will talk about that just briefly, but more importantly, it's having a roadmap, a path forward, so the person doesn't end up with no money and then facing a private pay that they can't afford. So there are a lot of ways to reduce countable resources, but that's not what I want to talk about today. How do you reduce countable resources? You pay for your care. You can buy exempt resources. You can buy a car. You can invest in your house. You can buy a bigger house. You pay for services, for legal services, for caregiving. There's all sorts of things that people can do to spend down and might be part of a very smart spend down strategy. That's something that the elder law attorney is going to help you with. What else should you keep in mind when I'm saying no spend down required? Maybe what you're thinking of is, I can give away all my assets, right? I don't have to spend them down. I can just gift them. Well, that's true and it's not true. If you are 5 years in advance of needing long-term care, then yes, you can give away your assets with no consequence for Medicaid eligibility, because Medicaid has what's called a 5-year look-back rule. And what that means is if you give away your assets within or 5 years in advance of needing care, Medicaid doesn't matter to them. So there are planning opportunities there. Sometimes there is a family legacy property. For example, a cabin, a lake cabin. That is something that you can give away so that it's not going to interfere with Medicaid eligibility or that it won't be subject to Medicaid's lien. Talk to an estate planning and elder law attorney if that's your situation. If you know you've got this property that you want to keep in the family forever, then there's planning that can be done, not spend down, but it is transferring that asset out of your estate into, for example, an LLC, an irrevocable trust, something along those lines. There's some very good planning that can be done if you do it 5 years in advance. If you don't plan in advance, you can't wait to the last minute to give away your assets. If you do that, Medicaid says you gave away assets, you don't need our benefits. You should have used them for your own care. The rule is right now that if you give away $10,785, there's a 1-month penalty period of ineligibility. Where does that come from? That's the what the rate is for a nursing home currently. Right now we're in September of 2022. That's the penalty divisor, $10,785. So let's say you had You're not talking to an elder law attorney. So you're doing this on your own. You say, I have $150,000 too much. I'm just going to give it away to my daughter. If you do that, give away $150,000 using that penalty divisor, you'll have almost a 14-month period where you don't get Medicaid. How are you going to pay for your care? You gave away all your money. Medicaid won't impose this penalty period until you are down within resource limits and you apply. So bad plan. You've given away all your money. You have no way to pay for your care until you apply for Medicaid because you've impoverished yourself. This was all part of a terrible plan. So sometimes Medicaid will do what's called a hardship exemption. Typically Medicaid will say, daughter, get back that $150,000. And if you can't give it back, they'll cover you for your care, but they'll impose 150% penalty against your daughter. Might be hard to collect, but that's what they'll do. So these are all non-viable strategies at this point, giving away money without a plan. So what I want to talk with you about then are what can you do that won't create a penalty period? What options do you have to give away assets? So what I want to talk with you about are exceptions to Medicaid's rule, the rule that says you can't give away assets within 5 years. So what that involves is transfers which cause no penalty. So let me share my screen again. All right. So what this is an opportunity. Let's talk about this opportunity here, which is the Community First Choice Program. So for some people, their income is really low. You know, it's below what is $2,523. And the only income we're looking at is the person who needs to go into a care facility. So if we have somebody that all they have is Social Security and they have under this $2,523 in gross income, and that's likely to go up again October 1st, not sure, but it probably will. They can actually give away all their assets with no penalty, and Medicaid will pay for their care. This is an exception to the rule that you can't give away your assets. So remember that situation where I said that mom has $150,000, she just gives it away to her daughter, and that was a bad idea? It's not a bad idea in this case if she's going into an assisted living in an adult family home and they will take Medicaid and her income is below $2,523 because Medicaid will pay for her care. Who would have known? So when she does this, she files a Medicaid application. They do actually impose a penalty period, but not for the CFC program, but for the COPES program, which is a different program that pays for care as well. So during this time frame, if she stays in the same level of care and doesn't need to go to a skilled nursing facility, she's actually preserved her estate, $150,000, just because they dealt with a lawyer who knew Medicaid's rules. So this is a planning opportunity. It doesn't happen all the time, but it's definitely something that we would look for. And keep in mind that when people are moving into an assisted living or an adult family home, and let's say that they accept Medicaid, this is the same facility. This is not like a different level of care than other facilities. Think about this. A lot of facilities have a private pay period. Sometimes they make exceptions to the rule, but a lot of facilities have a private pay period. And, you know, so you're in there for 2 years privately paying, and then they take Medicaid. Did you have to move? Did you move to another facility? No, it's simply this exact same facility. Facilities want a private pay period because the pay rate they get is far higher under the private pay rate than when Medicaid pays, but they're willing to accept 2 years as a private pay. So don't think that the Medicaid pay, yes, it's less, but don't think the facility is any different because oftentimes it is not any different at all. So that's just one exception to the rule you can't give away assets. There are other exceptions to the rule that you can't give away assets. For example, and this is, these are simply written in Medicaid's rules. Now, I didn't mention this, so I think I should. Medicaid is a federal and a state program. So you have the federal law, which says something, and then every state has their own rules and about how they apply the Medicaid rules for long-term care. So I'm talking about the state of Washington. What I'm talking about is not necessarily applicable in Oregon or in Idaho or California or any other state. So if you're listening to this and not live, but later on, well, when it's posted, keep in mind, I'm talking about Washington. So don't rely on what I'm telling you if you're in a different state. It may be true, but it's not necessarily true. So what are the rules for where can you give away your assets with no problem, no penalty? Yes, you can. If you can give away your house to your spouse, that's a no-brainer. We do that all the time. Okay, you can give away your house to your disabled child, no penalty. When I say disabled, what does that mean? That means somebody who's on SSDI. Maybe your son has a bad back. You can give your house to him and all your assets, no penalty. What if your son is on SSI? There's no penalty to you, but if you give away your house, or not necessarily your house, but other assets to somebody who's on SSI, who's your disabled child, you're going to create problems for them for the benefits they get. So don't do that. Give away the assets to a trust that can be created, a Medicaid compliant trust for your SSI child. You can give away all your assets, they receive them in a trust, they keep getting their benefits, and you get Medicaid, no penalty. You can give away your house to a sibling if you've lived in the house with your sibling and they've had an equity interest with you for a year. You can give away your house to your caregiver child. They've lived with you in your house for 2 years, provided care. Without that care, you wouldn't have been able to stay home. There's a lot of exceptions to this rule and traps. One of the traps about giving your house away to your caregiver child is you must immediately qualify for Medicaid. You may not privately pay at an adult family home or assisted living. If you do that, the caregiver child exemption rule goes away. You can't use it. So that's something to be very concerned about. What else can you do? What else does Medicaid say you can do? I just talked about your house. Well, like I said, you can give away all your assets to a disabled child or to a trust for a disabled person who's under the age of 65. So if you have in your family people who are disabled, qualified disabled under Social Security, and Washington even has its own rule about what they accept as a disabled person, that's a planning opportunity. I want you to be aware of those, not that you're going to go out and implement this yourself, but this is something to keep in mind. Here's a way to give away assets, not spending them down, just giving them away to the people who you would want to have them anyway with no penalty. Okay. So let's talk about, first of all, before I get into certain strategies, I want you to be aware of that once somebody's on Medicaid, they can only have $2,000 in countable assets. Yes, I agree. That's an impoverishment standard. However, if you're the community spouse, you needed to qualify with countable resources that one point in time, the first day of the month, the Medicaid application was filed. That's called the financial snapshot date. So let's say that all you could have was the 59,000, or let's say you could have the 137,000, whatever it was. The community spouse was resource eligible on that first day of that month when the Medicaid application was filed. Medicaid benefits are given to the ill spouse. Thereafter, the Medicaid, the well spouse, the person who's not on Medicaid, their resources don't matter anymore. They could inherit $500,000. They could, somehow more money comes to them from whatever means. It doesn't matter, because once that ill spouse is on Medicaid, the assets of the well spouse, the community spouse, don't matter. So that's something to keep in mind as well. There's a couple of questions I'll come back to in a moment that are in the chat. So one of the reasons that you'll want to see an elder law attorney, even if you are able to file a Medicaid application because the person's within resource limits and the couple say they only had, 50,000 in countable assets, is that Medicaid will have a lien against any assets, or a state recovery against any assets that are in the name of the ill spouse. So here's an experience I've seen before, or a situation. Somebody's at a nursing home. The nursing home facility says, hey, we'll file the application for you. And the couple didn't have a lot of money. They already only had their house and 50,000 in a car and personal property. And the couple said, well, that sounds like a really good idea. I don't have to pay a lawyer. So the nursing home facility files the Medicaid application. Ill spouse qualifies for Medicaid. And what happens next? The assets are not transferred over to the name of the well spouse, the person who's not on Medicaid. You have to transfer the house to the name of the well spouse. You have to transfer the bank account into the name of the well spouse only. You have to transfer the car into the name of the well spouse, because if you don't, and the Medicaid spouse dies, let's say they've been in a skilled nursing facility for 11 months and Medicaid's paid $10,000 a month. That's, what's 11 times? $110,000. Medicaid has a lien against the assets of this couple, all because they didn't see an elder law attorney who helped them protect against the Medicaid lien. Yes, the nursing home got the ill spouse on Medicaid, but they did nothing. They didn't do the next step, because they don't know, and they're not lawyers. They don't do the next step. Protect the assets against the state. They didn't do that. So just because this couple seemed to have it easy, they got on Medicaid. Now what's going to happen is the state's going to end up with this couple's assets. They're not going to collect until the well spouse dies, but they will collect. So that's a really bad outcome. Another reason to see, estate planning and elder law attorney. So what I want to share with you now is kind of the topic, which was, how do you get on Medicaid? You have more money than this couple I just described. How do you get on Medicaid without having to spend down all of your money? So I'm going to see if I can share my screen and show you a particular strategy. We'll start with a married couple. So the clients have an $800,000 estate. They have a house and it's worth $400,000, and they have bank accounts, which are countable assets, that's worth $400,000. So what are we going to do for Medicaid eligibility? We know the house is exempt, so don't worry about that one. The clients are going to qualify for the larger amount, the $137,400, because the ill spouse needs nursing home care. Even with that, we still have $260,000 too much money. What are we going to do? Do we have to spend it down? Absolutely not. We take that $260,000, and a single premium immediate annuity is what is purchased. This is what's called a Medicaid compliant annuity. It is the type of annuity that Medicaid allows people to have based on the rules. what this annuity will do is it will pay back. In the state of Washington, it's a 60-month annuity. So if you take $260,000, divide it by 60, you will see that the well spouse, the community spouse, will get back $4,343 every month throughout the term of this annuity. So the Medicaid spouse is on Medicaid. The Medicaid spouse's income pays toward their cost of care. The well spouse's does not. The result is the ill spouse is on Medicaid. This couple was allowed to keep their $800,000 estate, which was not just consisting of the $400,000 house and $400,000 in countable resources, because we took what was countable and took the excess amount, the $260,000, and made it non-countable by purchasing an annuity that Medicaid authorizes. So this is an incredibly useful planning tool. So this is one of the things that I want you as a married couple, if you're listening, to be aware of. If you're facing a long-term care situation, don't feel like you need to spend down your money. You don't. We have that Medicaid compliant annuity available to us. We use it. That way we can ensure that the well spouse is not going to run out of money, because the well spouse doesn't need to spend down. So that is the key, the most important planning tool for married couples. We want to make sure that you have the right estate planning documents in place. We want to make sure that you've got wills with supplemental needs trusts. Those I'm not going to go into in depth today. We've got other talks when we discuss that. Basically, the will with the supplemental needs trust makes sure that the assets are not going to disqualify the ill spouse from Medicaid. So under that last strategy, we put everything in the name of the community spouse. Community spouse bought a Medicaid annuity. If the community spouse, the well spouse, dies before the ill spouse, if the community spouse has a will with a supplemental needs trust in it, on that death, none of the assets are going to go outright to the ill spouse. They're going to go into a trust that Medicaid allows, a trust that's created by a will. And because of that, ill spouse is still going to be on Medicaid. All the assets that funnel through the will to this trust are not going to disqualify the ill spouse for Medicaid. They're all going to be in a trust for the ill spouse. And ultimately, when the last spouse dies, they're going to be divided according to what the will said, and the state's going to get nothing. So we can protect all of the assets. So for couples, really good planning available. When it comes to singles, what kind of planning, single people, what kind of planning do we have? Keep in mind all of those exempt transfers we talked about to a disabled person or to a caregiver child, that sort of thing. But let's assume that we couldn't do any of those transfers, and what we're talking about now is a single person. See, the reason that couples planning is so much easier is that we have this Medicaid annuity that's available. If you're a single person, well, we don't have a community spouse. We don't have this resource allowance. We don't have any of that. So we have to use other planning strategies for single people. And this is what I want to share with you. So we are going to be talking about single client Medicaid asset preservation strategies now. All right. So hopefully you are seeing my screen that says single client half a loaf gifting strategy. That's just the term half a loaf is something that we use here at ELG Estate Planning. It doesn't have really any legal definition. So if you were to look it up, you're not going to find this. So here's a strategy for a single person. They need adult family home care, It's going to cost $6,000 a month. They have income of $3,000. So they are short $3,000 a month. That's what we call the cost of care deficit. What are their resources? They have their home, it's worth $300,000, and they have a bank account that has $60,000. What should they do? Well, this is where they are going to be spending down some resources in order to qualify for Medicaid. A single person can only have $2,000. You know, if they wanted to buy a $60,000 car, they could do it. But I'm going to share with you something that's more commonly seen. They want to ready the house for sale because they can't live there anymore. And they're going to be part of their strategy is to sell the house. They're going to want to bury or, have an irrevocable burial plan. So that's all taken care of. They're going to buy a car, but it's going to be a modest car. It doesn't have to be $20,000 though. Literally, you can buy a $60,000 car and qualify this person for Medicaid. But they're going to, pay for care costs. They're going to pay for legal fees, whatever makes the most sense. And they're going to spend themselves down till they're at $2,000. We apply for Medicaid and Medicaid is approved. So this client is on Medicaid. Next step, oops, sorry about that. We are actually going to sell the home. So we sell the home. And then from the sale proceeds, we are going to gift to the very responsible daughter, who's the only heir of this person. I'm going to make it real simple, $230,000. And you're going to go, what? I thought we couldn't gift money. This is all part of our strategy. We intentionally incur a period of ineligibility. So we gift $230,000. We have the Medicaid client keep $70,000, and we tell Medicaid, DSHS, everything that's been done. They are going to say, okay, you gifted money. There's going to be a 21-month penalty period. How do we get through that penalty period? The client uses the retained funds, the $70,000, and pays for care during that 21-month period. Basically, they're going to need $61,900 to get through it. Remember, they kept 70. So at the end of that 21-month period, they might need to privately pay another month because we kept too much money, or they'll spend it on other things. We refile a Medicaid application, and the Medicaid client is again back on Medicaid with Medicaid paying. What was the result? For this client who had, keep in mind, a relatively modest estate as a single person, we were able to preserve $230,000 plus the car, which was a $20,000 car. So $250,000. The point of this is that even with single people, there are Medicaid strategies that may be available so that they don't have to spend down all of their money, so that everything that they worked so hard for will benefit their family without jeopardizing their care, without running afoul of Medicaid's rules, and without, any adverse consequences. Is this strategy right for everybody? Absolutely not. I just want to share with you that as an elder law attorney with Medicaid expertise, this is the sort of thing that we think about to see if isn't there a way that we can help the family, help the Medicaid client, if that's what they want to do. So that is the key strategies. I want to let you know that in order to do a lot of these strategies, let's say that single person didn't have capacity anymore. In order to do that strategy, we as elder law attorneys needed to have robust general durable powers of attorney that gave gifting authority. Without that, that type of strategy can't be done. That's a reason to work with a law firm that has Medicaid expertise, even if it's just your estate planning you're doing, because what we do, we're not just working with the clients at where they're at right now, we're helping them plan for where they're at until their death, which may include disability. It may not, hopefully it won't, but a firm like ELG Estate Planning will be thinking through all of those potentials. So some questions here. If you're not married, then here, let me see if I understand. As I understand it, many seniors are not married to maximize Social Security payments. Okay, that's true. In Washington, though, we have we recognize that seniors might not want to marry because they don't want to cause problems to Social Security payments or pension they get from a former spouse. We have something called the Registered Domestic Partnership Act. So if you're a senior, you're not married, but you want to have the benefits of Medicaid planning and keep the income from a former spouse, you can do so. Washington is a great state for making sure that you get the benefits of those both programs. So keep that in mind, that you might not want to get married, but you might want to become a registered domestic partner and get the benefits of all this Medicaid planning. If you're a single person, well, I guess you could get married or become a registered domestic partner or do some single planning. There was another question earlier about, I think it has to do with if you're doing Medicaid strategies and giving away assets, who can help you pay for your care if you're giving away assets. There's the ability to use certain kinds of trusts if they're appropriate. D4A trust, D4C trust, irrevocable trust with family members. There's quite a few things that can be done. Possible Medicaid annuities. If you're giving away your residence to a nonprofit, I'm not quite sure how that would work, but there's a possibility there. Let's see. So for someone that said, existing ELG estate planning, thank you for joining me today. I'm so glad that you did. You know, one of the things about doing estate planning is it's not static. It's not just, okay, my estate plan's in place and never talk to the lawyer again. We encourage that relationship. Keep asking us questions. If you have questions about long-term care or is a SPIA Medicaid annuity ready, appropriate for you now, things have changed in your life. One of the benefits of working with us as an estate planning and elder law firm is that we will meet with our clients, answer their questions, and we won't do so with a charge. Now, having said that, if we meet with you, we've done your estate plan 2-3 years ago, life has changed, and now you need a Medicaid plan, yes, we'll enter a new fee agreement with you and we'll implement that plan. But just that meeting, just giving that information, sharing our knowledge, we do not charge for that. We believe that that's part of what we should be doing, is making sure our clients understand their plan and what their options are going forward. So just reach out and contact us. We're at 509-468-0551. You can go to our website, elgwa.com. That's another way to reach out to us. For those of you that are part of this webinar today, we're going to be sending out an email with more information. But frankly, the easiest way to get in touch with us is to call us on our main number, which is 509-468-0551. So that is about all I had today. Before we sign off, thank you. I just want to make sure that if anybody else has any questions, happy to answer them. Otherwise, just feel free to reach out to us at the law firm. And I want to thank you all for being here today and for listening. Do share this information. If you know of anyone who might benefit from this information, please share it. Of course, it's going to be on our YouTube channel. We appreciate if you can subscribe and share and like that as well. So, all right, well, I'm going to be signing off. Everyone enjoy this beautiful weather we're having, and we'll talk soon. Take care now. Bye-bye. Thank you.